Hello everyone, this is Compass, navigating legal studies for your mission. This video is a legal essay practice for law students and bar exam takers. Today's topic is freedom of speech and the press. Problem: Echo Talk is a nationally broadcast radio program featuring debates on pressing environmental issues. 1 month ago, the government announced a plan to clear a portion of a protected forest to build a highway. Speaking outrage from environmentalists. On the least Echo Talk broadcast, two guests, pro-development and eco-activists, were invited to debate the plan. During the live debate, the following exchange occurred. Ecoactivists: This plan is an attack on nature. If the government pushes this through, it's a direct threat to our planet's future. Pro-development: We must make these trade-offs to benefit the economy and society as a whole. Ecoactivist: That's nonsense. This highway is nothing but destruction disguised as progress. I call on all listeners to blockade the construction sites, and if anyone sees pro-development, confront them wherever they go. He works at 56 Main Street, Suite 4. Let's make them understand we won't let this happen. A week after the broadcast, Pro-Development's office was vandalized, with the perpetrators spraying painting slogans against the highway plan on the building's walls. Ecoactivist was arrested and charged under two state laws. First, the incitement statute, which prohibits urging or inciting others to commit imminent unlawful acts. Second, the defamation statute, which publishes publicly making statements that unjustly harm another's reputation. Problem 1. Assuming eco-activist statements fall under the incitement statute, what constitutional argument can be made against convicting eco-activist? 2. Assuming eco-activist statements fall under the defamation statute, what constitutional arguments can be made against convicting eco-activists? Number 1. Issue: Can eco-activists argue that their speech is protected by the First Amendment despite the incitement statute? Rule: Under the First Amendment, speech is protected unless it falls into specific unprotected categories, such as incitement of imminent lawless action. Speech may only be published if, first, it is directed to inciting or producing imminent lawless action, and second, it is likely to produce such action. Analysis: Ecoactivists' statement calling for a blockade of the construction site and confrontation of pro-development could be interpreted as incitement. However, the call to blockade may not meet the imminence requirement, as it does not specify when or how this should happen. It might be considered abstract advocacy rather than an immediate call to illegal action. The statement to confront pro-development and providing their workplace address is more problematic. The resulting vandalism of pro-development's office suggests that this statement may have incited lawless action. If the court finds that the statement was both intended to cause imminent unlawful acts and likely to result in such acts, eco-activist speech may not be protected. Conclusion: eco-activists can argue that their speech was not directed toward inciting imminent lawless action and therefore is protected under the First Amendment. However, if the court finds that the vandalism was a foreseeable and intended consequence of their statements, the conviction may stand. Second issue: is eco-activist statement about pro-development defamatory and unprotected by the First Amendment? Rule: to establish the defamation, the plaintiff must show, first, a false statement purporting to be act; second, that is published to a third party; third, that causes harm to the plaintiff's reputation. For public figures, the plaintiff must also prove actual malice, that is, knowledge of falsity or reckless disregard for the truth. Analysis: eco-activist statement labeling pro-development's argument as nonsense is likely an opinion which is protected speech under the First Amendment. However, the call to confront pro-development and mentioning their workplace address could imply a defamatory intent if it suggests eco-activists are complicit in unethical or illegal acts related to the highway project. Whether pro-development qualifies as a public figure would impact the standard of proof. If pro-development is a public figure, eco-activist statements would need to be shown to have been made with actual malice. This could be difficult to prove, as the statements are likely rhetorical or hyperbolic rather than factual. Conclusion: eco-activists can argue that their statements were either opinion or rhetorical hyperbole, and thus not actionable under the defamation statute. If the court finds that the statements are not provably false or were not made with actual malice, the statute would not apply. Let's wrap up this session by revisiting the key rules. Under the First Amendment, speech is protected unless it falls into specific unprotected categories, such as incitement of imminent lawless action. Speech may only be published if, first, it is directed to inciting. Speech may only be punished if it is directed to inciting or producing imminent lawless action, and second, it is likely to produce such action. To establish defamation, the plaintiff must show, first, a false statement purporting to be fact that is published to a third party that causes harm to the plaintiff's reputation. For public figures, the plaintiff must also prove actual malice, that is, knowledge of falsity or reckless disregard for the truth. Thank you for watching. See you in the next video. God bless you.